A lot of clients are confused about what an arrest warrant is, and also people in the general public seem to feel that just because an arrest warrant has been issued against someone, that probably means that person is guilty. That is not true. An arrest warrant is only an allegation made by a police officer. I'm attorney Allan Friedman. I thank you for watching my videos. So, what is an arrest warrant in Connecticut? There are two ways that police can initiate criminal proceedings in Connecticut. The first is from their personal observations based upon what is known as speedy information. These are the kinds of arrests that the police make when they are on the scene of a crime. They are known as on-site arrests. The arrest warrant is the second way that arrests occur in Connecticut. The arrest warrant process involves a police officer writing out a sworn statement of a list of allegations against you, which the officer feels proves you committed a crime. It is important to realize that our criminal justice system is an adversarial process. The way the system is designed, people who are accused of crimes are allowed to have criminal lawyers like me to defend them and present exculpatory evidence to contest the allegations against them. The problem with an arrest warrant is that when a police officer drafting an arrest warrant, there is no defense lawyer there to keep the officer honest, to make sure he includes all the facts, even those facts which may show that you're innocent. There is no one there to overlook the work of the police officer to verify if the assertions contained in the warrant are accurate and reasonable based upon the actual evidence, or if they're over-exaggerated. In practice, police leave out any information which tends to support your innocence, and they only put in the bad things to try to paint the worst possible picture they can. They do this because at this point they feel that you're the guy who committed the crime and that they got you. Often police are unable to be open-minded enough to consider there could be other suspects. Many police officers see their jobs as being agents of the state's attorney's office. They don't see themselves as people who are looking to discover the truth. The reality is that a police officer can write whatever they want in an arrest warrant, and if a state's attorney or judge feel that there's probable cause that a crime occurred and sign off on the warrant, you're going to be arrested. So what is probable cause? Probable cause to arrest someone exists when the facts and circumstances within the police officer's knowledge would lead the officer to reasonably believe that somebody has committed a crime. Probable cause is more than a hunch or mere suspicion, but does not require proof beyond a reasonable doubt that the person has committed a crime. Notice that probable cause does not mean that you're guilty. Probable cause does not mean that you do not have defenses to the allegations contained in the warrant. You can only be convicted if a jury finds the state has proven its case beyond a reasonable doubt. Often an arrest warrant is issued and you're arrested. The media and the press are going to publicize the allegations all over the internet. Your employer, family, or friends are all going to look at you differently. You may lose your job. It's going to affect your reputation. You're going to go through a lot of stress and expense to clear your name. The worst part is that you may have had defenses to the allegation and the case may ultimately wind up getting thrown out. But the damage is already done. I'm going to put a link in the description below to a case I'm working on right now where the arrest warrant against my client is totally unfounded. My client's been subjected to a lot of media attention. I've been fighting really hard to clear his name. I'm confident I will be able to convince the state's attorney to drop the case, but nobody should have to go through this type of nightmare. Why I always feel good when I get a case against one of my clients dismissed. I'm very understanding of what it must feel like to be falsely accused of a crime you did not commit and have to go through the embarrassment of going through a criminal arrest. Sometimes when the police first contacts you, it may be possible to take a proactive approach by contacting a criminal defense attorney right away who can work to gather exculpatory evidence as quickly as possible to attempt to convince the police not to file an arrest warrant in your case. The best success stories I have as an attorney are the cases you will never hear about because we got involved early in the process. We prevented our clients from making self-incriminating statements to the police. We got our investigative team out pounding the pavement, gathering evidence to prove our client's innocence. Many of these situations, every year, people are never arrested. They say that an ounce of prevention is worth a pound of cure. If you've been contacted by the police regarding a criminal investigation, don't make any statements before first speaking with an experienced criminal defense attorney. Make the police build the case against you. Don't make their job any easier by assisting them. Remain silent and don't consent to any searches of your property, home, office, or cell phone. Thank you for watching for today's video. If you'd like to speak with me about any legal matter, feel free to call me for a free consultation anytime. If you're interested in these kind of videos, please consider subscribing to the subscribe button below. You'll be notified when we post future videos, and I thank you so much for watching.